In 2019, Colorado passed the Minor Conversion Therapy Law, a statute designed to protect youth by outlawing treatments aimed at changing a minor's sexual orientation or gender identity. The statute diagram covers physical interventions, but as those fade, we are left with a prohibition on purely verbal treatments, banning any conversational effort to change behaviors. Chiles, a clinical counselor, seized on this language, launching an as-applied challenge against the state. Chiles does not prescribe medication or use devices. Her practice consists entirely of sitting and talking with clients to help them reach their stated goals. Colorado defends the law by leaning on its traditional police powers. The state argues it is simply regulating substandard medical conduct, ensuring professionals adhere to an established clinical standard of care. Chiles counters that by silencing her words, the state is censoring pure speech. Because she only talks, she argues the regulation must be measured against the highest level of constitutional protection. This creates a direct clash at the Supreme Court. The justices had to determine exactly where regulable medical conduct ends and protected free speech begins. Resolving this boundary paradox split the court. To settle the case, the justices produced 3 distinct legal frameworks, each defining the limits of state authority over the professional-patient relationship in a different way. The justices did not reach a unified consensus on how to define professional speech in the modern era. Instead, the bench split, producing 3 competing intellectual frameworks to navigate the tension between state police powers and the First Amendment. To understand the future of medical regulation, we must map the logic of the majority, the concurrence, and the dissent side by side. Writing for the majority, Justice Neil Gorsuch starts with a foundational premise regarding the nature of the spoken word. For Gorsuch, talk therapy is quintessential speech. A state cannot reclassify those words as conduct simply by labeling them a therapeutic modality. Relying on a precedent called NIFLA, the majority rejects a blanket professional speech exception that would give the government broader power to regulate license holders. Holding a state-issued license does not force a citizen to surrender their First Amendment rights. This logic tree maps Gorsuch's framework. First, is the state regulating speech or conduct? Because Chiles uses words, the pat highlights speech. Second, is the regulation viewpoint-based? The answer is yes, triggering strict scrutiny. The statutory text itself demonstrates this ideological discrepancy. Section B explicitly permits therapists to express acceptance, support, and understanding for a client's identity exploration and development. But Section A criminalizes words that attempt to change that same identity or orientation. Colorado argued the law only incidentally burdens speech while regulating medical conduct. Gorsuch rejects this defense. The Minor Conversion Therapy Law does not accidentally sweep up speech while regulating physical actions. It targets the communicative content of the therapy session directly. So what? For the majority, the state cannot use its licensing power to enforce a specific ideological orthodoxy behind the closed doors of a private therapy session. Justice Elena Kagan filed a concurring opinion, offering a cautious, technical agreement with the majority. Justice Sonia Sotomayor joined this concurrence to draw a specific line for future medical regulations. Their core agreement with Gorsuch is precise. This Colorado statute suppresses one side of an ideologically charged issue while aiding the other, which constitutes viewpoint discrimination. This matrix charts Kagan's boundary. Plotting Colorado's law, it lands in the viewpoint-based, content-based quadrant, failing constitutional muster. But Kagan plots a different point in the viewpoint-neutral quadrant, indicating a potential path to survive. She explicitly refers to viewpoint-neutral standard of care regulations. Standard medical regulations, like requiring a doctor to inform a patient of surgical risks, are not automatically unconstitutional just because doctors use words to deliver that care. Kagan leaves a structural backdoor open. States can likely regulate professional speech, provided they do not engage in the official suppression of specific disfavored ideas. Justice Ketanji Brown Jackson offers a fundamentally different worldview regarding speech in her dissent. Her core thesis is that context completely dictates the First Amendment's true power in the professional medical sphere. Jackson argues that speech inside the professional-patient relationship is not part of the public marketplace of ideas. It is a tool for delivering medical care. She reinterprets precedents like NIFLA and Casey to argue that the state has always been allowed to restrict a provider's speech as part of a medical treatment. In her view, regulating a treatment is inherently regulating professional conduct, regardless of whether that treatment is physical or verbal. Jackson's logic tree asks two questions. First, is the interaction inside the professional-patient relationship? Yes. Second, is the speech part of a medical treatment? Yes. Under this model, the state only needs a rational basis to regulate, making any speech impact merely incidental. Jackson's issues a severe policy warning about what the majority's logic might unleash. If medical advice is protected as pure speech, traditional malpractice laws could be weakened, as providers might claim First Amendment protection for giving dangerous, substandard advice. This could also threaten informed consent requirements and existing bans on demonstrably harmful clinical practices. By erasing the boundary between public speech and medical treatment, the dissent warns the court has crippled the state's ability to protect patients from dangerous quackery. Comparing these frameworks reveals the new constitutional reality. Jackson's dissent didn't carry the day, leaving Gorsuch and Kagan to set the boundaries. Where a regulation targets an ideological viewpoint held by a licensed professional, the state's regulatory power drops to zero. Chiles v. Salazar functionally eliminates the state's ability to regulate the speech of licensed professionals if that regulation picks an ideological side. The ruling effectively dismantles the professional speech doctrine as a tool for viewpoint-based regulation. The idea that professionals have diminished free speech rights when treating patients no longer applies if the state is targeting specific ideas. However, just as Kagan's concurrence leaves one technical frontier open, it remains to be seen if a state can successfully enforce a ban on speech-based therapy if that ban is written to be purely viewpoint neutral. Ultimately, the court ruled that a medical license is not a First Amendment waiver, cementing the spoken word as untouchable